That was some of the prosecution's opening statement in the Yesenia Sesmas case out of Kansas. This woman who is on trial for the murder of a young mother, as well as the abduction of her 6-day-old baby named Sophia. You can't make this stuff up. It's really sad, and really we're trying to understand why did this happen, and now we have a better understanding of how the police actually targeted Yesenia. Now, here's what we're going to do. We are waiting for the live feed in that courtroom. As soon as we have it, we'll make sure to go into it. But there's a lot of things that we have to analyze in this case. So joining me right now is my good friend and criminal defense attorney and law and crime trial analyst. You have so many titles.
A lot of titles.
Ken Belkin, again, good to see you.
Jesse, good to see you. Good morning.
Good morning. So let's talk about this case. I want to talk about the defense because this is what I have to understand. I don't know if you had the opportunity to see the defense's opening statement, but it was like going to law school. They just were like, this is the definition of knowingly. This is the definition of reckless. This is the definition of this.
Oh, God.
And they said, if you don't, we hope that you find our client not guilty, but if you should, maybe not the severest degree of homicide. What I'm sensing here is they're trying to say that this was all an accident, but what's going on here?
I mean, look, the weight of the evidence in this case is almost crippling from a defense perspective. I mean, I think their best shot is to really attack the fact that maybe they can't prove that this was premeditated beyond a reasonable doubt, and thereby they can avoid a first-degree murder conviction. But look, this woman, you know, you've got a witness after the fact, the boyfriend that came in that can attest to the gruesomeness of the crime. That's going to really jar members of the jury. You've got this witness, Miss Portillo, that, you know, sometime back, a few months back, she sort of pulled a very similar stunt, trying to kidnap her 10- and 3-year-old daughter.
Yesenia Sesmas tried to kidnap this other woman's daughter.
Yeah, and then you've got what I think is really the smoking gun here, no pun intended, is the fact that when she was in police custody, she made statements that she admitted to doing this.
Right, she said she went there.
Yeah, this is why they tell you, you know, anything that you say can and will be used against you. You make a statement like that, it's going to be introduced against you. And people, you know, when they hear that you admitted it, when jurors hear that you admitted to these crimes while in police custody, that is really hard fact to walk back.
We saw the defense really didn't cross-examine these witnesses that were on the stand yesterday really at all, and we saw the testimony of baby Sophia's father talking about when he came home and found this horrific scene of his girlfriend shot in the head, and I don't even know if you want to say even worse, but the baby, his baby daughter was missing throughout the house. We saw this really unbelievable body cam footage from one of the officers, the first officer who responded to the scene, walking through this crime scene. And you saw police officers come and check the whole house. There was no baby. Ken, what we're going to do is we're going to take a quick break, but when we come back, I want to dissect a little bit more about this defense theory that Laura was really going to give Yesenia this baby and they had an agreement, or that the gun went off accidentally. We'll talk more about that after the short break. Welcome back to Law and Crime, folks. Did you hear that? That was a very interesting detail in the Yesenia Sesmas case, okay? This was the prosecution's opening statement, and they are trying to unravel the motive here. Why would Yesenia Sesmas, who is on trial for murdering Laura Barca and then stealing her baby, why would she do this? Let's talk a little bit more about it with Law and Crime trial analyst Ken Belkin. Ken, this is what we just heard. That Yesenia, the defendant, was pregnant and she had a miscarriage. Didn't tell anybody she had a miscarriage. She still appeared pregnant because she was eating a lot, stole the baby, and passed it off as her own. Have you heard anything like this?
No, not in my day-to-day life. Not the type of people I usually hang out with.
Well, that's good to know.
But, you know, it's bizarre. I mean, I feel bad for the defense attorney in this case. This is a really, in my mind, an unwinnable case.
Well, they're saying, the prosecution is saying, look, the defense is going to argue that Yesenia and Laura had an agreement, that Laura didn't want this baby, Sophia. Yeah. But all the evidence in that apartment says otherwise, right?
Even if, let's say they had some sort of bizarro, whacked-out agreement where she was going to give Yesenia the baby. Why does Yesenia show up to this transaction with a gun? Why, you know, Does someone end up dead? That doesn't matter. A weird arrangement is not an excuse for a murder and a kidnapping.
Yeah, this, again, there's a lot that doesn't make sense. If you look around the apartment, there's baby toys, baby supplies. Laura kept saying how excited she is to be a mother. Manuel, the father, was excited to be a father. There's nothing that says, I don't see this agreement unless they had some sort of oral communication. They talked in person, said, hey, listen, I really want to give the baby up. But that doesn't make any sense because, like you said, she came with a gun. And if you introduce a gun into that apartment, how on earth can she say, oh, well, it was an accident, the gun went off, it was a total misunderstanding? If you bring a gun into an apartment, aren't you creating that danger? Isn't that whole idea of an accident thrown out the window?
Well, no. Look, if she lawfully possessed the gun, which it doesn't appear she did in this case, you know, she's permitted to bring the gun with her and introduce it in all sorts of situations. What she's not permitted to do is to pull it out and fire it. And look, there might be, I think probably the defense attorney's strategy is, best case scenario, we get to defeat the premeditation element in first-degree murder. And maybe we get to defeat a little bit of the intent, and we could show that maybe this is an accident. She didn't intend to kill her.
Okay, I'll tell you what, Ken. Let's stand with that theory that this might have been an accident. Well, the process.
I'm not standing.
Well, that's not standing.
I'm saying that's a best case scenario.
Okay, let's stick with that for a second, because the prosecution addressed that in their opening statement. If this really was an accident, look very carefully at Yesenia's actions after the shooting. Is this what somebody would do if it really was an accident? Take a look. Okay, so that was some interesting tidbits in the prosecution's opening statement in the Yesenia Sesmas case. Welcome back to the Law&Crime Network and Law&Crime on Sirius XM Radio, Channel 109. I'm Jesse Weber, and I am guiding you through this case out of Kansas. A woman who is on trial for shooting and killing a mother named Laura Abarca, as well as kidnapping her 6-day-old baby named Baby Sophia. So the prosecution said, okay, the defense wants to say that maybe this was an accident. Maybe Yesenia went to Laura's apartment just to threaten her with a gun, and the gun accidentally went off. But if it really was an accident, why did she leave her there to die? Why did she not call 911? Why didn't you do anything that you would need to do to save someone's life if it really was an accident? Ken, what do you think about that?
I mean, personally, I hope she takes the stand to testify to that, although I doubt she will, you know, because I think the cross-examination by the prosecutor would be riveting. Oh, so, and it was an accident, right? But you didn't call 911, right? You didn't wait around for the police. You left with the baby, right? Is that what you normally do in an accident? You know, I think it would be great. I think what they're going to try and do is they're probably going to try and defeat the premeditation and intent on cross-examination of the people's witnesses, because there are no eyewitnesses here, which is probably, you know, the strongest
so expand
thing.
That. What do you mean exactly? You mean that they might be able to defeat that?
Like, look, they're gonna put the arresting officers on the stand. They're gonna put Portillo on the stand. They're gonna put the boyfriend on the stand. And you know, when it comes down to it, when you cross-examine them,
he was on the stand.
You know,
and really, we didn't see a lot from the defense.
Well, you know, but they're gonna be able to say, look, you weren't there, right? Mm-hmm. You didn't see the events take place. Mm-hmm. You didn't see Yesenia Sesmas shoot your wife, did you? And he'll have to answer, you know, no, I did not. And no one really saw it happen. So that's the strongest card that the defense has to play. But it's really not that strong of a card, especially when you stack it up against the other evidence, in my mind, the statement, the admission.
In other words, since nobody actually saw the shooting, but we know that her...
It's purely circumstantial, the case.
Well, what about the idea that when you look at the body, you look at Laura's body, she's slumped over, it looks to be a close-range shot. She was not in a position where she defended herself based upon blood on her forearms. They said, look, that would, because it's on this part of the forearm and not on the back, she didn't try to block herself.
There's no struggle.
So it's a betrayal of trust in a way. You fire someone right in the front of the head. What did you make of that?
Yeah, I mean, look, not a good situation for the defense. Would not want this case. That the forensic evidence is going to line up against them. You've got, you know, the circumstantial evidence, the boyfriend introducing the jarring scene to the jury. Mm-hmm. You've got Miss Portillo, who she tried a similar stunt on her 10-year-old and 3-year-old daughters. And you've got, lastly, the statement in police custody, you know, which was probably heavily litigated pre-trial, because if I was her defense attorney, I would want that statement suppressed. But the fact of the matter is, you make a statement in police custody, whether or not you've been Mirandized, if you just make the statement, you know, contemporaneously out of nowhere, they can use it against you.
Ken, you make a great point that it's an uphill battle for the defense. So what we're going to do right now is play you some of the defense's opening statement and listen very carefully to how they craft their argument. This is very different than the passion and seasoned opening from the prosecution, where they tugged at those heartstrings, and rightfully so, because of the tragic nature of this whole situation, this whole case. But listen to the defense's opening. It's very clinical. And as I said, it's kind of like being in law school. So again, this is the defense's opening of them defending their client, Yesenia Sesmas. Take a look. Welcome back to Law and Crime, everybody. I'm Jesse Weber, and that was the defense's opening statement in the Yesenia Sesmas case, a woman who is on trial for the murder of a mother named Laura Abarca. It's alleged that she shot her in the head in her home and then stole her 6-day-old baby named Baby Sophia, and this baby miraculously was recovered in Yesenia Sesmas' apartment. The baby is okay, but unfortunately, you have to think about this. This young child will be growing up without a mother. Let's talk more about this with Law and Crime trial analyst Ken Belkin. What'd you think of that defense's opening statement?
Look, I'm going to say this as plainly and as clearly as I can possibly say this. You have a duty to zealously advocate for your client, regardless of what they are charged with, whatever terrible things are alleged about them. You have to zealously advocate for them. If you cannot do that, you should find another line of work. And this guy was equivocating at every step in his opening. You may or may not find premeditation. No, you will not see any evidence of premeditation or intent in this case. They cannot prove beyond a reasonable doubt that this was not an accident or just a horrible situation that got out of control.
So why did he do that? Why was it so a definition by definition of the words in the statute? Don't you lose a jury doing that?
I mean, look, I can't tell you what's going on in his mind. My best guess would be that this guy is not too thrilled with having this case. It's probably, if I were guessing, I don't know for sure if he is a privately retained counsel or if he is an assigned, public defender or otherwise assigned by the court. But for whatever reason, it does not seem like he's very thrilled to be there. Look, it's a tragic case, and you have to have that sobriety, that somberness when you deliver an opening in that case. But that doesn't mean you do it in such a way that it looks like you don't even want to be there. You have to show some passion. It is your job to persuade these people.
And you don't think he persuaded anybody in that?
Look, I've been accused at times of, and I probably was when I first got into this line of work, one of those young, naive defense attorneys that thought all of his clients were innocent. So I'm usually on the defense side. And okay. I'm not seeing it here.
All right, well, we'll have to see what the defense ultimately does or does not do. See how I just did that, does or does not do, in this case. We're going to take a quick break. When we come back, we have a lot more to discuss in the Yesenia Sesmas case. We'll be right back. Welcome back to the Law and Crime Network and Law and Crime on Sirius XM Radio, Channel 109. I'm Jesse Weber, and I am guiding you through this new case that we're covering here. It is the Yesenia Sesmas case out of Kansas City. We were playing you some testimony right there of this was the father of this baby Sophia. So let's take a step back. The defendant is on trial for shooting and killing a mother named Laura Abarca. She had a baby, 6-day-old baby with Manuel, who you just heard from, 6 days old. Well, it's alleged that Yesenia killed Laura, shot her in the head, and then stole this baby from their apartment. And then Manuel, he's the one who discovers the crime. He's the one who walks in and sees the worst situation you can possibly see. So as we wait for the live feed in that case, let's talk a little bit more about his testimony. I'm here with Law and Crime trial analyst Ken Belkin. Can you imagine? Can you imagine being Manuel and walking in and seeing that?
No, I mean, a 6-day-old baby, this is supposed to be the most joyous time of your life. To see probably the scariest thing imaginable to someone when you walk through that door. And look, and this is what the prosecution wants to impress upon the jurors, that this is the worst possible day in this guy's life. This guy was happy as all hell to be a new father. He was happy, that this baby was in him and Miss Abarca's life, and just taken for no reason.
What's really sad, and when you think about it, is baby Sophia.
Yeah.
growing up without a mother.
Yeah.
How does he even explain this to her?
Yeah, that's
You know what I
a
mean?
tough one.
I don't know
And
how.
look, and I hate to be cold and cynical and look at it from a trial strategy standpoint, but this is highly effective testimony. You can't listen to this guy's testimony. You and I were just listening to this guy's testimony, and we are about as cynical as they come. And let me tell you, we were both affected by it.
Of course, I mean, you can't not be. And some of the interesting things was, and what you kind of got the flavor of from his testimony and other witnesses, there was no breaking and entering of the apartment. There was nothing stolen from the apartment. There was not a window that was broken into. The door wasn't jammed. That's what makes this seem calculated. So when you're sitting here, if we didn't know, if I'm an investigator, and I don't know that Yesenia Sesmas took this baby, I would first try to think, well, somebody knew the defendant. I mean, somebody knew the victim, excuse me, right?
Yeah.
So they trusted this person and let them into the apartment. Isn't that what you would get at?
Yeah, absolutely. I mean, just because, the assailant was known to the victim, it doesn't mean that, that doesn't necessarily prove premeditation or intent. It just proves that, that the person didn't have to break
In
into
other
the house.
words, somebody came in, and there could have been an argument.
Yeah, it could be an accident.
Maybe she came in, because we don't really know what happened in that apartment.
Yeah, and look, they're gonna push that aspect that we don't really know. No one was there, no one witnessed it, and it could be an accident. They're gonna push that hard. If I were them, I would probably push some form of a mental health defense here.
Well, I think our very own Aaron Keller made a good point about this, that they might not have that available to them. The defense might not have that insanity plea to their defense, because that seems like something that maybe they wanted to explore. I'm not passing judgment. I don't know the entire case. But when you have a situation where you said it yourself, the defendant has admitted to being the shooter, I'm not sure why that wouldn't be explored.
Yeah, and even in a mental health defense would be very tough to make out in a case like this. I don't think, I think it's probably better than going the accident route, because nothing about this really screams accident. Maybe there's a pinhole of doubt there that they're going to try to whittle away at. But, a mental health defense also comes with its own challenges. I mean, look, if you have to prove that the person didn't know the difference between right and wrong at the time. If she didn't know the difference between right and wrong, why did she flee?
We're going to talk more about that, because the defense stressed that in their opening statement. But what I want to do right now is we keep talking about Manuel, the father, what he found when he opened that apartment. Let's listen in. This is exactly what he found when he went into that apartment that day. Okay, that was some very important testimony. That is the father of baby Sophia in the Yesenia Sesmas case. Baby Sophia, this is a really sad situation. The defendant in this case, Yesenia Sesmas, is charged with the murder of baby Sophia's mother, as well as the kidnapping of Sophia. Manuel Gonzalez, the person you just heard, talked about when he walked into his apartment, Laura Barca, the mother of baby Sophia, was shot dead in the head. She was shot right in the head, slumped over on a couch, and baby Sophia was nowhere to be found, talking about what that was like. And he also said that they never, ever, ever heard of an agreement between his girlfriend, Laura, and Yesenia, the defendant, that Laura was going to give up her baby. So we talked a little bit earlier about why not try to say insanity here. Let's talk about that a little bit more. Again, I'm here with Law&Crime trial analyst Ken Belkin. So insanity is not actually an option in Kansas. In other words, if you look at the statute, it says if someone has a mental disease or defect, if that would negate an element of the crime, that might be a way for them to go. But it's not otherwise available to them as a defense. Can you explain that a little bit more?
Yeah, well, Kansas, and this is a little bit crazy to me, Kansas is one of 4 states in the country, the others being Utah, Montana, and Idaho, that does not allow for mental health defense, an insanity defense, which is pretty incredible.
So in other words, she can't say, look, I have some sort of mental disease or defect. I couldn't control my actions. I couldn't control my behavior. That's not available.
It's not an option.
But if she said, look, because of some mental disease or defect, I didn't form the intent to kill. I couldn't form the intent to kill. Maybe she said, I didn't know what was going to happen when I pulled that trigger. Maybe that is a different way of exploring it.
There's no possibility of them getting a not guilty by way of insanity here, which, by the way, doesn't mean, the person gets to go free. It means they go to a psychiatric hospital for usually some form of indefinite period of time. But not an option here. It's either she's going to jail or she's going home. And more than likely, she's going to jail.
When we get back, we have a short break. We're going to talk a little bit more about what are the ways under the law that she might be found not guilty, and perhaps saying that she didn't know what a gun could do is an option. Although I like exploring these scenarios, but it might be a stretch. But we really do have to say that because the defense in their opening statement were so keen on saying these are the definitions of reckless, knowingly, intentional. We want you to really understand what this is. And so when we get back, we have a short break right now. We are going to come back and talk about the Yesenia Sesmas case, and we are still in verdict watch in the Shaun Harrison case. We'll be right back. Thanks, Aaron. That was a great summary about where we're at in that case. So let's talk a little bit more about it. I'm here with Law&Crime trial analyst Ken Belkin. So, Ken, here's where we're at. He faces 10 different counts. He already his attorney in his defense, in his closing argument, said you can find him guilty of the 3 possession of weapons charges, but there's still drug possession charges. And really the main crux of this case is the charges in connection with the shooting of Luis Rodriguez, the attempted murder. So they've been deliberating for about 4 hours since yesterday, maybe even 5 hours right now. The question that I have for you is, could you see, are they deliberating for so long, maybe they've already decided about the drug and gun charges? I mean, ammunition, guns, drugs, they were all found in his apartment. But how are they really focused on right now the shooting, and maybe they're not so committed on that?
Well, it's hard to speculate what's going on inside the jury room, but
I
would say it is a lot of fun to do. And if you're on trial, you can't help but doing it because you want to know what's going on inside that room. You want to know what's going on inside their heads. Now, you know, look, it's 10 charges. They're going to go through. Each charge has elements to it. You know, 1 + 2 + 3 = 4, or 6 rather. And they're going to go through each charge and each of the elements individually and talk it through as a group and vote on it. Now, I do think there are probably some issues with the attempted murder, given the fact that the victim in this case made some prior inconsistent statements. And that is, you know, usually when your story changes, defense attorneys in general like to point to when a story changes as evidence that story is not credible, it's not to be believed.
Well, on one hand, you have the victim testifying, pointing the finger at Harrison. You have other students saying that Harrison told them that he was going to kill Luis Rodriguez. You see a back-and-forth conversation between Luis Rodriguez and the defendant in the hours before the shooting. We knew that they were going to meet up that night. And you see surveillance footage of what appears to be the shooting, but it's hard to tell if that's actually Harrison.
It's very grainy.
It's a very grainy footage, and you sit back and you try to wonder, well, is that person running away? Is that the shooter? Is that Harrison? Who is it? And I wonder if that's actually a reasonable doubt.
Yeah, this surveillance footage, by the way, in my experience, surveillance footage, it's never clear. It's always grainy. It's almost comical why we even have these cameras. Well, you can't see anything.
There you go. All of our viewers can see it, and all of our listeners. You see 2 figures dressed in dark clothes walking in a snowy area. One has an outstretched hand. It appears to be firing a weapon at the other. The other person falls to the ground, and the shooter runs away. Moments later, that victim, Luis Rodriguez, stumbles up and walks into the middle of traffic to get help. We're going to cover this case. As soon as we have a verdict, we will let you know. Again, this is the Shaun Harrison case out of Massachusetts. But before we go into our other case, the Yesenia Sesmas case, we have the top crime stories of the day. And I guarantee you some of them will definitely raise your eyebrows. Take a look. Thank you, Anthony. That's probably my favorite story I've heard in quite some time. Wow. Wow. I encourage all of our listeners on SiriusXM Radio to go to lawandcrime.com. I want you to see the mugshot of this guy. Doesn't look like Captain Kirk.
You a Star Trek guy or a Star Wars guy?
I don't know what I am after that story.
Yeah, me neither.
I'm a fan.
I think I'm going to stick with Han
I'm a fan
Solo.
of Anthony Velez for finding these stories. We'll talk more about that in a minute. But Ken, stand by. Here's what we're going to do. We are going to recap right now the Sesmas case, the one that we are really focusing on right now, the one that we're waiting for a live feed in. Again, Yesenia Sesmas is on trial for the murder of Laura Abarca. She's accused of shooting her in the head and leaving her for dead in her apartment apartment, but not only that, stealing her 6-day-old baby named Sophia. These are murder charges, kidnapping charges, and interference with custody charges. What we are going to do is, as we wait for the live feed to continue in that courtroom, I want to play you the testimony of Gary Jordan. This is a retired Wichita police officer who was the first responding officer in this crime. And anybody who joined our program yesterday saw and heard the body cam footage from this man. He was wearing a body cam footage as he approached the crime scene, and you see him talking to a panicked Manuel Gonzalez, the baby Sophia's father, as well as the boyfriend of Laura Barca. You see him enter into the apartment, and you see Laura Barca slumped over on the couch, and he searches the entire apartment, and there's no baby Sophia. So let's learn from him what happened on that fateful day. That's the testimony of Gary Jordan, the responding officer in the Yesenia Sesmas case out of Kansas. I'm Jesse Weber. Welcome back to Law and Crime on Sirius XM Radio Channel 109. Ms. Sesmas is on trial for first-degree murder, kidnapping, and aggravated interference with parental custody. And this is because it is alleged that she shot a young mother in the head named Laura Barca and stole her 6-day-old baby. And we're trying to make sense of what has happened so far in this case as we wait for the live feed in day 2 of this case. Let's bring back in Law and Crime trial analyst Ken Belkin. So what this officer was talking about is he was the first one to respond on scene. He sees the victim slumped over on the couch. And one of the interesting things, and we talked about it earlier, was that the defense, or at least Yesenia said to police originally, I had an agreement with Laura to take baby Sophia. She didn't want her anymore. That was the thing. But based upon the conversations and text messages and after the direct examination of the boyfriend here, there was no indication that was true. And if you look around the apartment, there's baby toys. There's everything you need to raise a newborn. There was no indication.
I mean, look,
that
this is distraction at best. This is totally irrelevant. Even if there was some sort of adoption deal gone awry, theory of defense here, that's not really a theory of defense. That doesn't give her a license to then commit a murder and a kidnapping.
Well, does it explain, look, I didn't want to come to that house to kill her, but after she refused to give the baby, I took out the gun, and it was a confrontation that accidentally went off?
Look, and like I said, that's their best shot here, but come on, not a very believable shot. I mean, especially when you take into effect that in the past year, she pulled a similar stunt with Miss Portillo.
Explain that a little bit for our viewers. We haven't, the jurors haven't seen that yet, if they'll see it, but we know that Yesenia Sesmas had tried to do something very similar, what was it, months before this happened?
Yeah, within the past year, she went to her friend's house, Miss Portillo, who had a 10-year-old and a 3-year-old daughter, and she attempted to kidnap them. She told the mother, I believe it was at knife point, that she needed her to duct tape her children up, and that she was taking them with her so she could ransom them for $10,000. It was a whole crazy scenario. And the mother, in fact, who was pregnant at the time, believed that maybe that Yesenia was after her yet-to-be-born child.
Unbelievable. And that maybe they'll be able to show a pattern.
Yeah, I mean, look, the defense probably really tried to keep it out in pretrial proceedings, but I would bet that it's coming in. It certainly seems relevant to me. It
definitely seems relevant in this kind of case. What we're going to do is we're going to take a quick break. When we come back, there's a lot more to discuss in this case, as well as an upcoming case here on Law and Crime. Stay tuned. Welcome back to the Law and Crime Network and Law and Crime on Sirius XM Radio Channel 109. I'm Jesse Weber. We have a lot to talk about, a lot of cases that we're covering here on the network, including one that is not looking so good for attorneys. Now, I love being an attorney, but really what I don't love is when I see fellow attorneys get into trouble. So let's go to North Carolina. There's a case that we're waiting to start. It's called the case of Wallace Bradsher, this district attorney who is accused of conspiring with another former district attorney named Craig Blitzer to hire each other's wives for no-show jobs. What does that mean? In other words, they hired each other's wives, and they got paid for work that they didn't really do. We have a short report about this case, and we'll talk about it. Take a look.
The trial of a former district attorney accused of conspiring with another prosecutor to hire his wife for a no-show job is set to begin this week in North Carolina. Wallace Bradshear faces felony charges in connection with the scheme he concocted with former Rockingham County District Attorney Craig Blitzer to hire each other's wives and allow Blitzer's wife, Cindy, to receive $48,000 in unearned state income. Authorities began investigating the work arrangement of the wives after receiving a tip from a staffer in Bradshear's office claiming Cindy was being paid for work she didn't perform. Both men resigned, and Blitzer accepted a plea deal in exchange for his testimony against Bradshear. Bradshear has unsuccessfully tried to have the charges dropped, the judge removed from the case, and a gag order enforced against prosecutors. He is also representing himself. If convicted, Bradshear could face more than 18 years in prison. I'm Anthony Velez for Law and Crime.
Thanks, Anthony. Let's talk about this case a little bit more with Ken Belkin here. So, Ken, this is an interesting one when we see attorneys in hot water. Would you do something like this?
No, but I am not an assistant district attorney. I'm a defense attorney.
No, they went for a loophole here because under the laws, you couldn't, the ethics rules, you can't hire your own family members.
Oh, yeah, a lot of loopholes, a lot of loopholes.
You can't hire your own family members, so they did a loophole where they hire each other's wives. Well,
I have a feeling that these prosecutors spent too much time prosecuting members of organized crime because their behavior is akin to that. They're acting like mob bosses. I mean, this guy looks like a mob boss, number one. But, you know, come on, hiring each other's wives for no-show jobs? This is what mob bosses do when someone gets out of jail. They give them a no-show job on a construction site.
Is it
not in a courthouse? Come on.
The jury, they're trying to find a jury for this right now, their jury selection. Is it hard finding a jury for this?
Yeah, I mean, I think it's going to be tough because this is you know, an assistant district attorney that's accused of a crime. And this DA's office has probably touched the lives of a lot of people. And people's lives in the jury pool have been touched one way or another. Either they were prosecuted, family members were prosecuted, or they were victims, etc. They probably had some contact with this office, and it's going to be a little bit challenging to get a jury pool that's not tainted on some level. Do
you think it's strange that this attorney Bradshear, the defendant here, is representing himself? I mean, in today's day and age, every attorney who gets in trouble, they hire outside counsel. They don't represent themselves.
Well, look, the number one thing is, as an attorney, you know if you're a defendant, anything you say can and will be used against you. It can. Your statements are evidence. And one of the benefits of having an attorney is that the attorney can speak, and with limited exceptions for adoptive admissions, you know, they're not really, anything they say is not going to be used against you. Now, what's the old saying? Someone who represents themselves has a fool for a client? Pretty true.
Well, here's what's interesting is that Craig Blitzer, his co-conspirator, is probably going to testify against him, and Bradshear is going to cross-examine him. Right? Isn't that a possibility?
I mean, it's going to be brilliant. I wonder if Bradshear...
Did I say this?
Yeah. I wonder if Bradshear is going to take the stand and question himself on direct.
I mean, that'd be amazing.
That would be brilliant.
Hope. We can only hope. So that is one of the cases that we're covering here. We are waiting for it. That's in jury selection right now. If something should start up, we'll make sure to go to it. But I want to bring it back right now to the other case that we're waiting for. This is the case, the live feed that we are waiting for, and it is the Yesenia Sesmas case. So this woman is on trial for the murder of a mother named Laura Barca, as well as the kidnapping of her 6-day-old baby, baby Sophia. Yesterday was day one in the case. We saw the opening statements from both the prosecution and the defense. We saw the beginning of testimony from key witnesses, including the father of baby Sophia, who was also the boyfriend of Laura Barca. We saw the testimony of one of the responding officers who saw that horrific crime scene of a mother who was shot in the head and a baby who was missing. Now I want to play you the testimony of Catherine Rada. She's a crime scene investigator who took photos of the crime scene. And I warn you, some of this is difficult to see in the sense that you're looking at a crime scene where a baby was kidnapped and a mother was shot. So it's difficult. It's difficult, but in a case where the prosecution is building evidence against Yesenia Sesmas, it's very important. Take a look. Welcome back to the Law&Crime Network and Law&Crime on Sirius XM Radio, everybody. So that was the testimony, or some of the testimony, of Catherine Rada, a crime scene investigator in the Yesenia Sesmas case out of Kansas. A woman who is on trial for the murder of another woman named Laura Abarca, as well as the kidnapping of her baby Sophia, who was only 6 days old when she was taken. Luckily, baby Sophia was okay. She was rescued from Yesenia's apartment, and it's a miraculous story about how she was ultimately rescued. We'll talk about that a little bit later on in the program. But as I said, viewer discretion advised, because Catherine Rada took photos of the crime scene, and you saw Laura Abarca there, slumped over in the couch with a bullet hole right in the center of her forehead. Let's talk about that a little bit more with Ken Belkin. Ken, I know our time together is coming to an end, but I want to talk about the crime scene. Based upon the trajectory of the bullet, based upon the way that she was seated, investigators and prosecution are saying that there was no struggle, that she didn't try to defend herself. What does that tell you about this case?
I mean, assuming that the body wasn't moved at all, this looks like, in my mind, a textbook execution-style killing. Very cold, very calculated. You know, look, I think proving premeditation is a little bit difficult. There are no witnesses. But look, she did bring a gun there, as you said, and the way the wound is set up on her head, the scene of where the body was found, this looks like nothing more than an execution.
Because they said her forearms had blood on them, and it was at the top of the forearms and not the inside, which said she wasn't trying to attack her in any which way. She was seated. The cartridge that came out, or I might be getting the terminology wrong, when you fire a gun, it comes out. It was on the right, which would say it was at a close-range shot. It's pretty deliberate.
She's comfortably seated. This wasn't someone that appears to have been standing up or otherwise active in any way.
So she can't argue, hey, there was a struggle, I came in there to be peaceful with Laura, talk about the baby, and there was a struggle between us. No, it looks like...
I mean, she can argue it, but from the photos, it doesn't seem to appear that way.
We'll have to see which way it goes. Ken, thank you so much for joining us.
Thanks for having me, Jesse.
Of course. So we are going to play you a little bit more of the testimony from Catherine Rada as we wait for the live feed in this case. This is when Catherine starts going over, or Ms. Rada, I should say, starts going on some photos that were taken of the apartment, but this is key. Yesenia's defense, or at least what we think that they might say, is that there was an agreement between her and Laura that Laura would give baby Sophia to Yesenia. If that's the case, then why was the apartment filled with toys and filled with baby supplies and filled with every indication that this is somebody, a mother, who wanted to keep her baby? Let's play you some of that testimony right now.